Las Concordia, I welcome the opportunity to contribute to the debate today on the Fines Payment and Recovery Bill 2013. And I think when you consider that there is over 8,500 people were incarcerated last year for non-payments of fines, I think the general purpose of this bill has to be welcomed, because the situation where we have so many people ending up in jail for non-payment of fines is just untenable and shouldn't be allowed to continue. And I think that the bill will contribute to removing that from our society, and I think that's very important. I would have some concerns in relation to the actual act itself, the bill itself, and some of the provisions governed in it. And I think it's interesting also when you look at it that the 2010 Fines Act, a lot of the provisions in relation to the recovery of fines haven't actually been implemented yet. So we're not really basing this on a need to change legislation that's already here, because it simply hasn't been enacted. While it's been passed by the Houses of the Oireachtas, it hasn't been implemented, and I think that's not a good system of operating a fines recovery system across the state. The Act itself provides for the attachment orders to be placed on wages of people who have been fined and to be paid in instalments. And I know it has been raised by a number of members, but I think it's important is that the period for the payment of the instalments is different under this Act than under the 2010 Act, where the period is for 12 months only under this proposed legislation. And I think the Minister needs to look at that and needs to amend that at committee stage and later to extend it to at least the 24-month period, because I think for people in society who have received fines, and they may not even have to be very large fines for them to have difficulty to be able to discharge them within the 12-month period, and I think it definitely has to be extended and to at least the 24 months. I think also the ability of the person to be able to pay a fine of any sort has to be taken into account when the fine has been levied, and the courts should be very cognizant of that, particularly in the current climate. Section 6.5 provides for the provision of an administrative charge of 10% on persons paying fines by instalments, and I think this is excessive. I don't believe that a 10% administration cost would be in evidence in relation to the processing of fines, and particularly when you consider that they can be done through an IT system. There may be an initial cost in implementing a system, but I think that should be carried by the state in the interest of the public good, and it shouldn't be seen that the court service may be actually profiting on the payment of fines by instalments if the 10% fee and 10% charge is maintained. And I think, the worrying aspect in relation to this legislation is that we see that the court service in their 2012 report say that they're still not in a position to be able to accept fines by instalments, and have highlighted that they need their IT systems updated to ensure that they can do that. And I think when you consider that this has been on the statute books and paying in instalments since 2010, although it hasn't been implemented, I think that that's a very worrying situation. And are we going to see this time next year, or 2 years' time, or 3 years' time, where the court service haven't been able to step up to the mark? And I think it's something that has been flagged for so long, that they should be ready to roll out a system of paying by instalments at the immediate stage when this act is implemented, because the system will just collapse otherwise. And you have people who actually would be willing to pay by instalments, but the court service probably won't be in a position to be able to accept them. And I think that would be totally unacceptable for citizens in this state. And I think I'm not sure if it's covered in the bill, but it should be provided for, is where people can pay through the post office or through the local council offices of that as well, similar to the car tax and TV license and everything else, so that the avenues and the options available to people to make payments should be as broad as possible to facilitate them in doing that. And the Section 6 then also provides for the fines under €100 not to be eligible for payment in instalments, and I think this should be looked at seriously by the Minister as well, because I know many families at this stage and many individuals where a €100 fine could place a severe burden on them, and the difficulties in being able to get €100 together to discharge a fine can't be underestimated. For some single people living on job seekers allowance at €188 a week, to be able to pay €100 in a once-off system like this would be unattainable for them. So I think the level that the payment by instalments can come in has to be looked at and has to be adjusted as well. And also just note with interest in the Bill's Digest that was circulated in relation to this legislation, it appears that there is a problem due to social welfare, that social welfare recipients, whether the fines can be deducted from them because of the levels allowed. But the Social Welfare Act earlier this year changed the levels that people can be deducted at to, I think it's 15% of their social welfare payment. So I would hope that this isn't only intended to allow people who are in work to be able to pay their fines by instalments, but that it will be intended as well for people, recipients of social welfare, so that they can benefit from the instalment process too. Because we will see a situation where possibly the only people who would end up being incarcerated for non-payment of fines would be social welfare recipients if they aren't able to avail of the the payment by instalments as well. And I think that's very important. In relation to the appointment and the right to be able to appoint a receiver to confiscate property to allow for fines to be discharged, I think this is probably a very serious development, and something that needs to be considered very carefully and looked at very carefully. I think definitely there should be a minimum level of fine under which a receiver wouldn't be appointed. Probably we've seen over the last few years that receivers is probably one of the few growth industries that we've had in the state, the amount of receivers that have been appointed to properties and to companies across the country, and to have another raft of receivers appointed recovering the value of fines, I think is something that we need to consider very carefully. And it really should only be in exceptional cases and in very high levels of fines that a receiver would be considered. And particularly when you see that it actually appointing the receiver will add an additional amount to the cost of the fine, because the receiver's fees will be paid out of the person whose property has been confiscated to make that fine recoverable. And I think also then in section 11, I think it's where somebody doesn't, or where recovery of assets isn't possible, that a community service or imprisonment may follow. And it just seems that the courts don't have to consider that first, and they may go straight for recovery of assets. And I think that it should be that they should consider the community service element, particularly in advance of recovery through confiscating assets, because I think community service doesn't incarcerate a person and can add some value to the community that they come from, and discharging that fine.
A minute and a half left,
Oh, no bother. Thank you, Leslie. I think I'm finished with that. I just will be possibly putting forward some amendments at a later stage in relation to some of the issues I've raised, and I would ask that the Minister would consider some of those arguments in relation to problems that we could foresee with the operation of the legislation. Thank you.